All right, guys. The last video here on civil liberties, we're going to tackle the Fifth Amendment and the protections that it entails. First, you've got the right to a grand jury hearing. What that essentially is, if you are being brought to trial, you are suspected of committing a serious crime, you're entitled to a group of citizens coming together and analyzing the evidence first and deciding whether or not there's enough to go forward with the trial in the first place. The difference between this and a regular jury is the regular jury simply decides guilt. Are you guilty? Here they're deciding whether or not you even should be considered guilty or innocent just based on the preponderance of evidence. All right, double jeopardy. Not just a game show here, but the idea that you're not to be tried for the same crime twice. However, that doesn't mean that it's like you commit murder and then you murder somebody else and you've already been tried for murder for this one person, you can't be tried for the other. It's really for the exact same crime. The exception to this is if you're talking about different jurisdictions. So if you commit a crime that could be considered a state crime, but also could be considered a federal crime, you could be tried in two different courts for that crime. Also, just because a case goes through the state court, for instance, O.J. Simpson. O.J. Simpson was declared innocent in a state trial, but he lost a lawsuit in which the lawsuit was brought against him by his former wife's family, for the harm he did to their family, and he lost that one. So it's not the same thing here. It's different jurisdictions, different situation when we're talking about double jeopardy. Self-incrimination. There's an important case to understand here. It's not one of the foundational cases that we need to make sure that we know, but it's interesting all the same. You have the right not to testify against yourself. That means in court, but also when being questioned. So because of the case Miranda versus Arizona, we have these things called Miranda rights. And that means that anytime you are actually being suspected of a crime, the police need to read you your rights before they start to question you. And essentially that is the right to remain silent and the right to have an attorney present. So if they start reading you those things, you should be afraid, and you probably should remain silent. All right. The Sixth Amendment, trials, juries, and attorneys. You have the right to a speedy trial, an impartial jury, and an attorney. Okay. The question came down to, is this a right that states had to incorporate as well? And it was determined because of Gideon versus Wainwright that it does. So this is a case that uses the incorporation doctrine to apply the Sixth Amendment's right to an attorney to the states. So the background here, you had a Floridian man who couldn't afford an attorney for a state crime. They refused to appoint a public attorney to him, and he was found guilty. So he appeals this, and it goes all the way to the Supreme Court. Now the question becomes, does the Sixth Amendment's guarantee of a lawyer apply to the states? And the Supreme Courts did decide to use the Due Process Clause of the 14th Amendment to incorporate this protection to the states. And so now if you are ever going to trial and can't afford a lawyer, it doesn't matter if it's a state or federal crime, you will be appointed an attorney if you need one. The Eighth Amendment, dealing with bail and punishment. The Eighth Amendment protects against excessive bail, excessive fines, and cruel and unusual punishment. And all three of these have now been incorporated to the states. Very recently, in January of 2019, the Supreme Court incorporated excessive fines now to states as well. So all three of these protections now incorporated thanks to the Due Process Clause. Gregg versus Georgia determined that the death penalty is not cruel and unusual. However, that it doesn't mean that the death penalty can be applied to just anybody. For instance, if there are mental disabilities of the defendants or if they are juveniles, they're not to be convicted and punished by the death penalty. Then I got a map here that shows you the different methods that each state has. Great concept of federalism here, how each state can approach it differently. I'll let you pause the video and take a closer look at that. We'll talk about that in class. And then we got the Ninth Amendment. Rights not specified. According to Federalist 84, Alexander Hamilton was nervous about the whole concept of a Bill of Rights. He feared that listing one's rights assumed that if they're not listed, they're not protected. So enter the Ninth Amendment. The whole purpose of the Ninth Amendment is to satisfy these fears from Alexander Hamilton. And so it states that individuals have rights not expressly mentioned. And this is going to be a nice little lead into the next protection we have, and that is the right to privacy. So with the right to privacy, it's assumed by several different amendments. And I'll be honest, I've seen different texts approach this from different ways and mention different amendments. But the ones that keep coming up here, first, third, and particularly the Fourth and Ninth Amendment create what we call our right to privacy. So it's nowhere directly stated in the Bill of Rights, but it's assumed by a collection of them. The big case that actually led to the concept that we have a right to privacy was Griswold versus Connecticut, and that was dealing with birth control, that states were trying to ban birth control, contraceptives. And it went to the Supreme Court, and it was determined states can't do that because we have a right to privacy of our own bodies, and they can't legislate whether or not we can use birth control. There's not a significant state interest to prevent people from using birth control. In the court case Roe v. Wade, a Texas law prohibited Roe from having an abortion. The issue became, does the right to privacy also cover abortion? And the decision was, as we all know, because it's a very controversial one for many Americans, is that they decided that abortions are constitutionally protected by the right to privacy. They did come up with some restrictions here, however. They came up with the trimester system. So the first trimester means unrestricted. You cannot put undue stress on women who seek to have an abortion in the first trimester. The second trimester can be regulated, and the third trimester is optional for states to even ban outright, unless, however, the mother or baby's life is in danger. Again, another great concept of federalism here. You can see how different states have created restrictions based on abortion, and this is from 2015. It's typical that you can see that liberal states have fewer restrictions and very conservative states are going to have more restrictions. Another case that involves the right to privacy was Lawrence versus Texas, and this was an anti-sodomy law that was challenged. Texas had banned the act of sodomy, which is anal sex, and it was targeting homosexual men. Went all the way to the Supreme Court. The Supreme Court decided that one's sexual activity, as long as it's consensual with adults, is a right to privacy and cannot be restricted by the government or states. All right, here's another graph here. We can see anti-sodomy laws that were repealed, and yellow showing ones that were repealed before 1970, and then ones in the really dark red which were repealed as a result of Lawrence versus Texas. So the dark red are the last to fall. Okay, guys, that concludes it. I hope this was beneficial for you, and bring any questions you have to class, and we will tackle them.